Mr. Chairman, members, HCR 2027 applies to Congress to a call for an Article 5 convention for the purpose of proposing amendments to the United States Constitution that imposes fiscal restraints, limits the power and jurisdiction, and limits the terms of office for officials of the federal government, and continues this application until at least 2/3 of the states have made an application on the same subject. I'm available for any questions.
Members, any questions for staff? And the bill sponsor is here, Representative Townsend.
Thank you, Mr. Chairman and members of the committee. I'm going to go off script just a little bit, and I am keeping my comments short in consideration of last week. However, the discussion today so far has reminded me back in 2008, the reason I got involved in politics in the first place, I was actually here at the legislature in Representative Carl Seal's office doing some citizen lobbying about pro-life issues. And Representative Seal brought to my attention HCR 2001, and I still remember it. And it was a 10th Amendment resolution putting the federal government on notice to cease and desist immediately from coercing the state of Arizona from passing laws in certain ways that they had wanted us to pass. And as a citizen, veteran, not involved in the political process, I was jaw-dropped to see that we even needed such a resolution. And since 2008, having gotten involved and feeling as a veteran, it was my duty then to be part of that effort to return our state back to its 10th Amendment rights. I haven't seen any progress. I haven't seen the federal government being placed back in its role. I did not see any positive response to that HCR 2001 and I believe it was 2008, possibly 2009. So that is why I stand here today. That is why I'm here, is because of my I was just aghast at how this is being handled. And so here I stand today, no closer to a states' rights situation than I was, 5 years ago. So I am more than pleased to offer this bill, this resolution, calling on Congress for a Article 5 convention. Do we have quorum? Everybody's left. Are we all right?
Well,
we're all right.
I appreciate that question. We do have a quorum at this time, but just for everyone's information that are watching the committee, I do have many members of the committee who have bills up for consideration in other committees, but they are available on a moment's notice. The pages can retrieve them if there is a quorum call or if we are ready to move to a vote. So they're just balancing their other responsibilities on their bills in other committees, but they will be here to vote.
And thank you for that. And for the benefit of the remaining members and for the public who's here, then I will continue with my comments. I want to discuss, and it's a responsibility of what we need to do as
Representative Townsend. If we can make sure that we keep our comments to the bill, but since the question has been raised whether it is appropriate for members to be testifying on their other bills, I will address that because it is a responsibility of these members, and these members have done a lot of put forward a lot of effort to educate themselves on this bill so that they can make sure that they can vote appropriately when the question does come up. They're running over to their other committee to testify on their bill as you are today on your bill, to represent their constituents well in the committees where their bills are being considered, and they will be here to vote. And if a quorum call is called, then they'll be available for that as well, and they'll return as soon as they finished testifying on their bills in other committees.
Thank you, Mr. Chairman. I would point out too that I am also missing my committee so that I can be here to testify. So I don't begrudge my colleagues at all. Okay, so I will just point out a few differences with what my bill is doing, or I should say your bill that I'm sponsoring here. The reason I chose this direction as a pure call, an Article 5 call that does not include the safeguards so to speak, is one, I was advised by Mike Ferris, who's going to be speaking after me, the importance of keeping those two things separate, that you want a pure Article 5 call specific to what we're going to be doing, word for word from what other 34 states are going to be offering, so that there's no excuse, no reason that Congress can say, sorry, you didn't do it right, start over. So we have a pure, without those safeguards call, and those safeguards are going to be offered in Representative Dials, which you voted on last week, for our delegates' selection and control for a so-called runaway convention. One of the other reasons why I am doing this rather than the compact is it's my understanding, Representative Lesko had asked us, it's my understanding that that the compact is going to need congressional approval. And I applaud all of those who are have the...
Representative Contreras has raised a point of order.
We've lost quorum.
Okay, a quorum call has been questioned. Pages, if you could go find the members who are testifying in other committees and have them return. We'll wait until a quorum has been reestablished.
I'm testifying. They're going to have to wait. Okay, thank you.
All right. At 5 we have quorum.
Representative Thorpe, can you give me my water?
Okay, members, by way of a point of order, a quorum has been established. Representative Kelly Townsend has the floor.
Thank you, Mr. Chair. As I was saying, the reason that I have chosen this direction rather than the compact is my concern that the compact is going to require congressional approval, and I personally don't have the faith that that will happen, and so I have chosen to go with also a pure sequential order of what Article 5 asks for. It's not compacted into one or two steps, but it's actually step by step by Article 5 without any deviation, so that there's no question that we have done it according to the constitutional requirements. The other issue that is different is this is not a single issue bill. This is going to have three different issues put into the same bill as we go together. If the convention is called and we have discussion, we have, of course, an issue with our budget. However, we also have other issues that we're dealing with. For example, we have had our own Senator John McCain has removed, according to Rand Paul, has removed in the NDAA, the indefinite detention of our American citizens. There was a provision that was added into the NDAA that would allow for protection for an American citizen to not be held indefinitely. Our senator has removed that issue. That's of a great concern to me. It's an example of federal power over the states and over our citizens here in Arizona, and it's my job, and I took an oath to protect them. And so for that reason, among many others that I won't belabor here today, not only is this bill addressing fiscal restraints on the federal government, but also limiting the power and jurisdiction of the federal government. And additionally, and I might add, has full bipartisan support, I would say, maybe not full, but great bipartisan support of term limits. Even my own dad, who's a full-on blue, it likes the idea of term limits. And I think that if we're going to be successful with an Article 5 call, we are going to need the support of our colleagues on the other side of the aisle. And I think this is one of those issues that we will see that, where we have term limits of Congress and other federal officials. And finally, I wanted to mention my time in Mount Vernon. When I went back to Mount Vernon with my colleagues to discuss the possibility of getting together and what those delegate controls might be, while we were sitting there, and I have, hopefully it's not on screensaver, can you see? This picture was being presented to us over the overhead of many different like big screen TVs all put together to project this image that I wish the public could see, but we don't have a projector. But it's George Washington staring at us for the better part of that meeting. And when I went there, I have to admit, I was not necessarily in favor of an Article 5. I felt like if these guys are going to touch our Constitution, I want to be there and make sure they do it right. And having gone through this whole process and learning, I am now a full supporter of this process. And one of the things that happened while I was there, having looked into the eyes of this man, this picture of George Washington, I asked myself, what would he say to us? Because this is a scary proposition. I will admit that there's a lot of unknowns here. And I understand some folks that are against this because of the unknowns and the what-ifs. But in looking in those eyes, I got three things back of what I think he would have said to us. And first of all, is to be decent. This man wrote at 14 years old a book about how to be decent manners, and I forget the exact title, but he was a decent man and a great man. And he would tell us, first of all, as we go through this, to be decent to each other. Second of all, is to be honest, not to try and deceive ourselves to achieve our goals, but most of all, to be brave. This man, what he went through, it took bravery. There was a lot of unknowns. But the times were very troublesome, much the same as they are now. And we face very similar issues that he faced. And he did not step aside and do nothing, did he? It took a lot of courage. And I'm asking all of you, and all of you who are afraid of this process, to consider what he faced and what his colleagues faced. Is that, what's the alternative? Is to do nothing. And if we do nothing, then it continues on. And we have more of the same. And some have called the same evil. There's this evil that goes on that we just don't want to tolerate. And so what's that saying? The only thing for evil to persist is for good men to do what? Nothing. And I'm not going to stand here and do nothing. I cannot. And yes, it is a frightening prospect, very unknown. But what's our alternative? And I don't want to be in the history books, as this goes down, to be on that side of someone who did nothing. I would rather try and fail than to not try at all. And so I ask for your support.
Thank you, Representative Townsend. Any questions for Representative Townsend? Representative Lesko.
Thank you, Mr. Chair. Representative Townsend. Since we already did the compact bill, so I understand the difference between that one and your bill. But the difference between yours and Representative Thorpe's, which we're going to hear next, is the only difference that his is confined to one single subject and yours is open to multiple subjects.
Representative Townsend.
Thank you, Mr. Chair. I wouldn't say it's an open call to any subject. And it is very specific to these three topics: the fiscal restraints, which is very, obviously we have two different bills on that issue. But also, like I said, the issues of the NDA and all the other encroachments. The reason I'm standing here right now is limiting the power and jurisdiction, might I say, jurisdiction of the federal government. And then, of course, term limits, particularly on Congress. So those three issues are the only issues that we can discuss when we come together for a convention.
Thank you.
Any further questions for the bill sponsor? Thank you for your testimony, Representative
Thank you.
Townsend. Next, we will hear from Michael Ferris. If you could please state your name for the record and who you represent and your position on the bill, and take a minute to describe your views on this bill.
Mr. Chairman, thank you so much. Members of the committee, thank you also. My name is Michael Ferris. I am the Chancellor of Patrick Henry College, where I teach constitutional law. I am also the director of the Convention of the States Project for Citizens for Self-Governance, and I'm appearing in that capacity today. Thank you for the opportunity to speak to this legislative committee. I watched last week's committee meeting, at least a substantial portion of it on the internet, and I will not be long. I will try to curtail my comments. Representative Townsend gave you a very good introduction. I'll just embellish a couple of points to explain the process that we're dealing with here. I have been an Article 5 litigator. I'm one of the few lawyers in the country that's actually litigated an Article 5 case. I represented 4 Washington state legislators in a case regarding the attempt by Congress to extend the ratification period for the Equal Rights Amendment. And as a result of that, I had 3 years of in-depth experience in learning the ins and outs of the Article 5. And that's really actually when I came to believe in the process that we have today, and that was in the late 1970s and the early 80s when we finished that litigation. The process that we're talking about here, we have drafted this. Rob Nadelson and I have drafted all these documents, have been done for the purpose of doing it correct by the Constitution and to avoid litigation. The problems with other approaches, particularly the various balanced budget amendments, because they've been written in such a differing fashion from state to state, we didn't want to have that problem of the aggregation issue coming up. So the states that are considering the Convention of the States application that we have drafted are all committed to following the exact formula that's outlined before you today in the portion of Section 1 that describes the purpose of the Article 5 Convention, limiting to fiscal restraints on the federal government, limiting the power and jurisdiction of the federal government, and limiting the terms of offices for its officials. Chairman Olson, I would indicate that the problems that you've outlined, at least all the jurisdictional problems that you've outlined, maybe not the pro-life issue, which I'm as a father of 10, I'm as pro-life as anybody in this room.
Very impressive.
Yeah, and grandfather of 17. This convention, the way we've written this, that would not be an issue. So despite Representative Wheeler's desire to bring that issue up, or my desire to bring that issue up at a later convention, it would not be germane under the application that we've written here today. But other than that one issue that you raised, virtually all the other issues that you talked about of federal overreach of power would be germane at a convention, particularly the issue of federalism. The Founding Fathers and every one of your constituents expects you all to represent them here. But in reality, when Congress tells you what you need to do, in many instances, and gives you mandates, sometimes funded, sometimes partially funded, sometimes unfunded mandates, the voters of Illinois and Massachusetts and California and New York are telling you what to do, not the voters of Arizona. And the only way to recover true federalism in this country is to do something broader than just a balanced budget. If we're going to retain federalism, because I would submit that the biggest problem that this country faces is there's a great, in terms of the federal government, is there's a great disparity between the Constitution as written as compared to the Constitution as interpreted by the Supreme Court. The federal government does follow the Constitution as interpreted by the Supreme Court, rather than as written. And the only way to fix that disparity is the process that we've outlined here. This is the method that George Mason gave us, and we're coming through the front door. The compact is a very inventive side door procedure to do this, and I'm glad that you just voted for that. I commend you for that. But it's not clear which process is going to get to 34 states most quickly, or in that case 38 states, plus Congress in that case. So we believe that our approach is the best approach. It has the best chance of actually limiting the power and jurisdiction of the federal government. And if it's successful, it's the only opportunity on the table that really limits federal power in a number of areas, not just in the area of balancing the budget, which I'm all for balancing the budget. I'm really glad those measures are proceeding. And so the way this happens is 34 states will pass the application, and those phrases will be exactly the same in all 34. Stage 2 is where the amendments, the precise text, are drafted. And if I had to guess right now, I think there would be something like 6 or 7 amendments that would emerge from a convention of the states of the kind that we're talking about under the application that we've outlined. And if there are 6 or 7, let's say 7, then just like the Bill of Rights, there would be 7 amendments put out, and you would vote each of them as individual amendments, up or down. 38 states. So if you don't like the term limit bill that comes out, you vote no on the term limit application. If you like the balanced budget and you like correcting the Commerce Clause so that Congress only has the ability to regulate shipping and no longer can regulate everything with a dollar sign associated with it, which is the current Supreme Court definition of the Commerce Clause, you vote yes on the Commerce Clause correction. Same thing for General Welfare Clause. If you want to fix each of these problems, then you can vote on each of the particular amendments. And so if there was a package of 7, then when you get to 38 states ratifying any 1, 2, 3, 4, 5, or more of those amendments, then and only then will they become amendments. The process for making sure that the delegates do what you intend them to do, historically, is both Rob Nadelson and my opinion that the best way to do that is with a separate measure, whether that's ordinary legislation like is being proposed today, or by simply when you name the delegates, you instruct the delegates. And so I think that that is equally valid and equally subject to the powers of this body, including contempt power and removal power and other powers. And so there's no doubt that you can successfully ensure that your delegates will perform what they're supposed to do. And if you appoint, my recommendation is you appoint something like 11 members to a convention, so that 6 of them would cast the vote for Arizona, because it's one state, one vote. They would caucus on each and every vote. And if you appoint 11 people, the chances of anybody doing anything crazy is pretty slim with 11 people, because you're going to appoint 11 responsible people, and if one of them goes crazy by drinking water weird or something, then that's going to be still hard to carry the day if you appoint 11 appropriate people. So the basics are, if we want to solve the problem of a runaway federal government, this is the only proposal that's out there. This is progressing well in other states. It's passed a committee in Alaska last week. I testified by phone there. It's passed the full Georgia Senate. It's going to be scheduled for a full floor vote in Georgia soon. It passed the Arizona Senate Committee today. Excuse me, I apologize. Florida Senate Committee today. Not the Arizona Senate today. And it passed. It has been considered. It's progressing in a number of other states. I'm being scheduled to testify in numerous state legislatures now. We expect final action in at least 10 states this year. So this is a rapidly moving measure, because the situation our country faces is dire, and we believe that if we're going to save this country, we got to get it in process now. The good news about our process, it does not require any discretionary approval of Congress at any stage. It's not going to be subject to any kind of successful litigation. It will move very quickly. And if we can get 34 states, we will be in a convention within 6 months after that, and we'll be back in ratification within 6 months after that. We can save this country. So with that, I'd be glad to answer any questions anybody has about any phase of this process.
Thank you, Mr. Ferris. I appreciate you coming out and testifying to the committee, and like you said earlier, I appreciate you keeping your testimony brief so we can proceed with the further public testimony and the business of the committee. But I appreciate the details that you've given us about the proposal that you've put together and the efforts that you're working on in other states, and I thank you for the work that you've put into this effort. Members of the committee, are there any questions for Mr. Ferris? Representative Steele.
Excuse me, Mr. Chair. Yes.
That's a sign.
Yeah. Hopefully it's not the end of the First Amendment. Mr. Chair, Mr. Ferris, the flow, what you talked about, I've talked to you a little bit before this committee hearing too, but the construct of your language here that you pretty much authored and have done in other states, Mr. Chair, Mr. Ferris, the two basic phases I'm concerned with. Phase A is the calling of the convention and the amendments, the people who go there, and what kind of constraints we put on. This call doesn't seem to have any, this language doesn't seem to have any real teeth there at all as far as holding the people that we send accountable. Can you help me understand that? You might have briefly done that. Forgive me, I have a bill in another committee that will save the taxpayers $1 billion, so forgive me, I have to
Mr. Ferris.
try to keep our state solvent.
Mr. Chairman, Representative Peel, I'm glad you're trying to save $1 billion. That's good. Thank you very much. The brief answer is, to avoid litigation, we have written this so that it's extremely clean and crisp. And we expect you will have to name the delegates. And whether you do this in parallel legislation, like Representative Thorpe is offering, that is a Delegate Limitation Act, that's a perfectly valid way to do it. Equally valid would be to have the resolution that actually names the delegates, as has historically been done, gives the limitations in that. When you give them their commission. I have an LLM in public international law, and this really is the practice of international law, because you're acting as a sovereign state. Sovereign states give delegates commissions, or they can be called commissioners or delegates. And when you give them their commissions, you give them their marching orders. And those marching orders are binding. It's like sending an ambassador to negotiate a treaty at the United Nations. You are sending your ambassadors to negotiate the specific language on an agenda that you've already set. The agenda is set by the application, the language is written, and you will give them directions, and they are required to obey those directions. And so it's just phasing it correctly. You will not, in any circumstances, be sending delegates to this convention without instructions. It's just done in the right sequence so you avoid litigation.
Mr. Chair, Mr. Ferris, what's to keep the federal government here from, they go to this convention, we tell them, talk about balanced budget, or in this case more than balanced budget, term limits and Article 10, or rather 10th Amendment issues. What's to keep them from going there and deciding they want to just, I don't know, wipe out the first 10 amendments, let's just say?
Mr. Ferris.
Mr. Chairman, Representative Peel, what prevents them is that the agenda is binding. There have been over 400 amendments in the history of this nation, or excuse me, applications from states. 49 states, including Arizona, on multiple occasions, have done applications. The reason Congress has never called a convention on Article 5 is there's never been 34 to reach the critical mass, reach the trigger point for calling the convention. The trigger point is agreement on the agenda. When the agenda is set, it's fixed in stone. It's like the case I litigated in the Equal Rights Amendment. When Congress proposed 7 years for ratification, the federal court ruled in that case it was fixed in stone. You can't change it once it's been done. Once the triggering moment has happened, that power has been exercised and it's gone to the next phase. When Congress said 7 years was binding and could not be changed. When the states say, here is the agenda, and we reach 34, the binding moment has happened, and you can't change the rules in the middle of the stream. I've successfully litigated that case in the federal courts before, and I will be confident I can do it again. And so and beyond that, the political reality is that the makeup of the state legislatures are such that they're going to send people to these conventions that are dedicated to a limited government. And the people for a limited government are not going to be interested in repealing the Bill of Rights. It will not happen. It's not germane. Congress can't change the rules. Congress doesn't have the authority to change the topics for discussion, change the agenda, any more than Congress had the ability to change the deadline once they established it. It simply can't be done lawfully. Can they purport to behave unlawfully? They could try it, but there are two checks. The states and the courts can both check them, and both check them very effectively.
Mr. Chair, Mr. Ferris, are you familiar? I know you mentioned Representative Thorpe's work around delegate control.
Yes.
Are you familiar with Representative Dial's bill that deals with a similar subject matter?
To that point, I'll just chime in. Representative Seal is referring to two bills. One we heard in this committee previously, and Representative Thorpe had another bill that was assigned to our committee after we had already put Representative Dial's bill on the committee. Representative Dial and Representative Thorpe have had discussions that I was a part of as well, and they are going to merge Representative Thorpe's language into Representative Dial's bill. So Representative Thorpe's language will be moving forward.
To that point, then, Mr. Chair, Mr. Ferris, then, Mr. Thorpe's language, which you tend to have more knowledge of, sounds like. In your opinion, what safeguards did those place, or constraints do they place on the delegates that go to this drafting convention?
Mr. Chairman, Representative Peel, the seal. I'm sorry.
Kind of like seal the border.
I'm sorry.
Spelled different.
I wish I could see your name tag. I can't. Representative Seal. I apologize. That's bad. I would not be able to give you the details. I've read the bill, but it's been a little while, and I've been out of touch because my father had a stroke 3 days ago, and I've been dealing with my father, so I don't remember the details. But I know the general principles, and the general principles are this, that when the state of Arizona's legislature gives directions to its delegates, they have to obey them. And you can put what penalties you want. I would recommend that you put in simple penalties, not complex penalties. I would recommend that you have the ability to withdraw the delegates. I think that that's all in there. And you have considerable discretion And so whatever you think is necessary, I think is fine. I think you can do it with ordinary a resolution rather than through the actual legislation, so you won't need the governor's signature. You can accomplish the same objective, but even that is not mandatory. You can do it any way you want because you possess plenary power to control the delegates in whatever fashion you wish. So I think that it's there's a dozen good ways to do this. This is one of the good ways to do it.
To that point, I'm sorry to hear that about your father.
Thank you, Mr. Chairman. I appreciate that.
Any further questions for Mr. Farrell? Thank you for your testimony.
Thank you.
Next, we will hear from. We have a number of folks who have signed in wishing to speak. Not too many, so we should be able to manage the testimony in a timely manner. We'll move first to Barbara Bluster, who wishes to speak in opposition to the bill.
Mr. Chairman,
Representative Wheeler.
if you would, you may give Ms. Bluster the recognition that she was a former legislator.
Absolutely. Former legislator, former representative or senator? Former Representative Barbara Bluster.
And you know, Mr. Chairman, the people I want to convince, some of them are not here. Well, okay. It's representatives. So, Mr. Chairman, thank you for the opportunity. So on regards to this bill that Michael Ferris wrote, I have some problems with it. I'll try and be quick. Whereas the founders of the Constitution of the United States empowered state legislators to be guardians of liberty against future abuses of the power by the federal government, and the federal government also has the 10th Amendment in it that they put in it. And that's what we need to be upholding. And we have been doing that through nullification this legislature session. And I'm very pleased about that. Down to the third whereas, has invaded the legitimate role of the states through manipulative process of federal mandates, most of which are unfunded to a great extent. Whose fault's that? That's our fault. Where have we been? It's not the fault of the Constitution. We have to have a spine. Go on down to line 21, 22. I better get the whole sentence in here. The legislature of the state of Arizona formally applies to the Congress of the United States to call a convention for the purpose of proposing amendments, plural, to the Constitution of the United States that will impose fiscal restraints. 2305 has no fiscal restraints. There is no decision to lower taxes. It provides for raising the debt ceiling by 5%. It also suggests sales tax, national sales tax, value-added tax, and eliminating the
Ms. Bluster, I hate to interrupt you, but make sure you're keeping your comments to HCR 2027 and not 20.
Okay, gotcha.
I know there's a lot of similarities,
Okay.
but just.
I made my point. Limit the power and jurisdiction of the federal government. That is already in the Constitution. That's already there. In fact, if we pass a balanced budget amendment, no, is that in here? Okay. If we pass any things to restrain things, we are eviscerating the enumerated powers. Eviscerating means disemboweling. We are getting rid of the restraints already in that Constitution. As for the Supreme Court, limit the terms of office of the officials of the federal government. That I want to address. And so, here's a quote from Dr. Edwin Vieira from Across of Debt. This debt we face is no accident, and this will explain it. At base, the problem reduces to an alliance between two voracious crime families. Avaricious, meaning greedy, bankers and financial speculators on one side, in league with ambitious, careerist politicians on the other. Their strategy has always been to link the moneyed class with the government's treasury. so as to advance the special interests of both families. The bankers and speculators incorporate the Treasury as an integral part of their business plans. The politicians agree to coordinate the Treasury with, if not subordinate it to, the bankers and speculators in order to ensure their own continuance in office. And the common people pay the costs. And that's going to go down a lot of generations. And when they talk about full faith and credit, what's that going to be? It's going to be our lands, the future work of our labor. There is no restraint. There's no point, and my point here is talking about term limits. You are going to find people that they get to that federal office and they're going to love to be in this banking cartel thing because their hands are out. Oh, my opportunity to secure myself in office by paying off my constituents. So their hands are all out. And aren't everybody's hands out? Hospitals, universities, cities, counties. And so our governors, all of them take unconstitutional federal money. Do they not? And you're going to have them as your representatives? The wolf is going to protect the hen house, of course. So I like Sam Adams' quote, "If you love wealth better than liberty, the tranquility of servitude better than the animated contest of freedom, go home from us in peace. We ask not your counsels or your arms. Crouch down and lick the hands that feed you, i.e., teachers, hospitals, cities, counties, etc. May your chains set lightly upon you, and may posterity forget that you are our countrymen." And his cousin's comment that chokes me up, so if I cry, forgive me. John Adams, "Posterity, you will never know how much it costs the present generation to preserve your freedom. I hope you will make good use of it. If you do not, I shall repent it in heaven that I ever took half the pains to preserve it." This Constitutional Convention is a trap. The expression, "the shot heard round the world," meant that every potentate at that moment on the green in Boston, meant that every potentate, king, chancellor, Caesar, czar, knew his system would end if the American cause for liberty won. Immediately, the Illuminati began May 1st, 1776. That's why the Communist International holiday is May 1st. That is, okay. The strategy for world government is patient gradualism. Very slowly mesmerize the populace, keep them slightly drugged with food stamps and stadiums. Sound familiar? This conspiracy is transgenerational and transnational. Their goal is world government and a ruling class. And this effort for a constitutional convention is falling right where they want you. Are there any questions?
Thank you, Ms. Bluster, for your testimony. Are there any questions? Appreciate your impassioned testimony.
Thank you.
Can we now hear from Joshua Cardin? Is Joshua Cardin here? Thank you. You'd state your name for the record and who you represent, if anyone, and your position on the bill.
Joshua Cardin, Mr. Chairman. Thank you for the time to speak today. I am a volunteer with the Convention of States project, and in hearing that passionate cry for liberty from the preceding speaker, I'm supporting House Resolution 2027 mainly for the reason that that's what I want too. I want that for my kids. I want that for my grandkids. I want to return to the limited government that our framers gave us. And lo and behold, the way to do that is right there in the Constitution. If you haven't read Article 5, I encourage you to do so. I'm amazed at how many people have never read it. It's the same article that the Congress has used 27 times to give us the amendments we have. The states get to propose amendments. The states get to ratify the amendments. That's the safeguards that we need, and that's why I'm supporting, not just with my speaking here today, but with my time and energy. And I would encourage the members of this committee to support the bill as well. Thank you.
Thank you. Any questions for Mr. Cardin? I appreciate you for coming down and testifying on this bill. You bet. Next, we'll go to Jennifer Reynolds, speaking in opposition to the bill.
Thank you, Mr. Chairman and members of the committee. I am opposing the bill today, and I am insulted oftentimes when people consider me not a constitutionalist because I won't use this provision in the Constitution. I am a lover of this country. I am a lover of this Constitution. I have this Constitution by my bedside, and I read it every day. I am here to testify to you today that those calling for an Article 5 convention ignore history. They seem to think that we can some way concentrate this into just a few amendments on the bill. Well, they ignore what's happened initially in 1787. The document known as the Articles of Confederation was the Constitution of the United States at that time. Its Article 13 mandated that regarding any changes to the Articles, and I quote, "Nor shall any alteration at any time hereafter be made in any of them, unless such alteration be agreed to in a Congress of the United States, and be afterwards confirmed by the legislatures of every state." When the Constitutional Convention met in Philadelphia in 1787, that legally binding and constitutional provision was ignored. It was ignored. From the moment Edmund Randolph stood and proposed what was known as the Virginia Plan, the Constitutional Convention of 1787 became a runaway convention. There is no debating this fact, because Article 13 prohibited any changes to the Articles without complete unanimity, agreement by all. This provision was not only disregarded, but was replaced completely by a new Constitution and created a convention. And with that, Article 7 of the Constitution now reads, "The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same." This is very different from the original Article 13 of the Articles of Confederation, and with this new provision, the unanimity rule, agreement by all, was no more. Despite constant reassurance by pro-Article 5 groups, there is nothing in this Article 5 that could prevent a convention of states from going down the same roads towards a runaway convention. Those calling for an Article 5 convention today are backed by numerous radical, progressive, and socialistic organizations that otherwise would have little in common with the conservatives fighting on the same side. George Soros, for instance, the financier of global fascism, is pumping millions of dollars into the same Article 5 campaign that is being promoted by Mark Levine, Rush Limbaugh, Sean Hannity, Glenn Beck, and many other popular conservative spokesmen. There are hundreds more groups committed to social and economic justice, ending corporate rule, and building a vibrant democracy, are gathered under the same umbrella. The potential proposals that can come out of such a radical groups boggles the mind. Remember, according to the history of the Article 5 style conventions, regardless of any state or congressional legislation requiring them to consider only one amendment, or in this case 3 amendments, the delegates elected to the convention would possess unlimited power to propose provisions to the existing Constitution. This is based on the inherent right of the people in the convention to alter or revise their government as stated in our Declaration of Independence. While changing the Constitution through another amendment, will this somehow magically put a Band-Aid on the gushing wound of the federal government and get it to balance their books? No. We need to cautiously guard the Constitution from changes and get back to our roots. We already have the power, as Barbara Bluster mentioned. We have nullification. I applaud so many of you who are putting forth bills this session to nullify the EPA, to stop the NSA, to stop the NDAA, for instance. We have the power already. We don't need to change the Constitution further. It's not broken. We, the people, are broken. We are not following it. Why are we not following it? Because we continue to elect the likes of John McCain, for instance. We continue to elect Jan Brewer, who's not constitutional. Shame on us. We cannot nullify the federal government, as long as we continue to have our handouts as states, we continue to accept federal funds, we cannot balance our own books. Shame on us for accepting 38% to balance our books here in Arizona. How can we expect the federal government to do any different if we're taking part of the pool? We the people can stand for liberty today and uphold the Constitution. I urge you to vote no on HCR 2027.
Thank you, Ms. Reynolds, for your testimony. Are there any questions? Representative Lesko.
Thank you, Mr. Chair and Ms. Reynolds. I think you said something. Can you repeat the part about George Soros funding?
Sure.
Thank you.
George Soros, the financier of global fashion, is pumping millions of dollars into the same Article 5 campaign as those promoted by Mark Levine, Rush Limbaugh, and other organizations, Glenn Beck, etc.
Okay. Thank you. And Mr. Chair and Ms. Reynolds, is there any proof of that? Because I've heard that before. I just don't know where did you find this information?
I found this information on online resources. The New American is a very good resource. There's the Turk organization, for instance. That's one of the biggies. The Move On organization, which has a lot of progressives like the Sierra Club and so forth that are promoting an Article 5 convention as well.
And so, Mr. Chair and Ms. Reynolds, is there like what kind of evidence? Is it just somebody online saying this, or is there like a money trail, or?
You can,
okay.
Mr. Chairman, Representative Lesko, you can track the money trail. I'd be happy to send you further information if
okay.
you request that.
Yeah, please do. Thank you.
Any further questions for Ms. Reynolds? Thank you. Representative Wheeler.
Ms. Reynolds, I don't know, were you here last week? Let me ask.
I was.
Mr. Chairman, Ms. Reynolds, we were having a discussion before we lost a quorum in which it was pointed out that every state but Vermont has a balanced budget requirement.
Correct.
And that every state that has a balanced budget requirement has violated that mandate, that requirement, that legal law in their constitution, including the state of Arizona, this building being the prime example of that. Any comments?
Mr. Chairman, Representative Will, you're absolutely correct. We are leasing out this building that was brought out last week, and how can we expect to balance our budget and have ratifying amendments if our state ourselves cannot balance the budget? Of course, we're going to continue to vote for debt ceiling increases. If we need 38% of our money from the federal government to balance our books. That's shameful. If we want to truly nullify and stop the federal government, we need to also stop and balance our books as well.
To that point, I agree, Representative Wheeler and Ms. Reynolds, that we do have some requirements in our state constitution that we levy a tax to cover the expenses of the given fiscal year, and unfortunately, the courts have considered certain types of debt as though it were not debt, and I have a bill that we will be hearing next week in this committee to address that will specify in our state constitution that lease purchase debt, certificates of participation, and so on and so forth, all are in fact debt. They are long-term obligations of the state, and they do apply towards the constitutional debt limit of $350,000. And so I will be looking forward to hopefully having your support on that amendment next week. But also to that point, it is interesting to compare. Notwithstanding the holes that the courts have allowed in these balanced budget requirements in our state constitutions, the debt that the state has, if I remember right, it's around $8 billion, which is less than our annual budget. When you look at the federal government, the debt is $17 trillion, which is 17 times approximately the federal budget, and so the extent of the debt and the fiscal problem at the federal level is much, much greater because of this lack of a balanced budget requirement in our state constitution. So notwithstanding the fact that there are holes in the state balanced budget amendments, it has had an important impact in maintaining fiscal responsibility at the state level. Are there any further questions for Ms. Reynolds? Thank you for your testimony.
Thank you, Mr. Chairman.
You bet. Next, we'll hear from William Bluster. We'll go ahead and call up who's going to be testifying after William as he's coming up. Next, we'll hear. Did you still want to speak? Okay. Okay, next, after William, we will hear from James Pinkerman.
Thank you, Mr. Chairman, members. I think the most important reason for defeating Article or HCR 2027 is that in all likelihood it cannot be confined to one issue or to even 3 issues as proposed. Regardless of any stipulations, limitations, or other restrictions that either the Arizona State Legislature or even Congress might impose or attempt to impose on the delegates to an Article 5 convention, the convention process is in actuality unlimited and could lead to unintended but yet harmful changes to the Constitution. And here's the point. The reason why the convention route of Article 5 is unlimited is because the Founding Fathers originally intended it to be that way, to provide a way for future Americans to, if the need ever arises, to abolish the current form of government and replace it with a new form of government and Constitution as stated in both the introduction and preamble to the Declaration of Independence, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it and to institute new government. That's why Article 5 was put there. Now, I'm not going to talk very much about why it is open. However, I would point you to your packet that you were given last week that has letters and statements from eminent jurists, from Warren Burger, Supreme Court Chief Justice, to other jurists, to law school professors, etc., as to why a constitutional convention, a Article 5 convention, a convention of states, or whatever it's called, cannot be held and cannot be kept from being a runaway convention. And then secondly, I think that the proponents of these bills, all of this whole mishmash of bills that have come before you and will yet come before you, I think they're basing their the whole thing on a house of cards. If you take an objective reading of Article 5 and read it specifically, Congress, after some other details, shall propose amendments to this Constitution or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures or by conventions in 3/4 of the states, as one of the other mode of ratification may be proposed. Now, nowhere in there does it say that the states can do this or this or this. It's under Congress jurisdiction. Congress makes the convention call. Congress tells what's going to happen at that convention. It tells who's going, what's going to happen, where it's going to happen, when, why, and how. Those 6 issues are included in every call for any convention that I've ever heard of or attended, and I've been to several. And so I think that we're reading something into the Constitution that's not there. And I urge you to consider the fact that our Constitution is not broken. Let's not mess with it. Or to put it the way you've heard a lot of times, if it ain't broke, don't fix it. I urge a no vote on HCR 2027.
Thank you, Mr. Blooster. Any questions for Mr. Blooster? Representative Smith.
Yes.
Thank you, Mr. Chairman. And thank you, Mr. Blooster. When you mentioned that it kind of seems like we're on a path to just abolish it, the Constitution, but you also said a part in there, too, that said, well, we can alter it.
Right.
So isn't that what an amendment is in the 27 previous amendments? The 27 previous amendments didn't abolish it.
Right.
Wouldn't you argue that we just altered it? So why would it be any different this time if we just wanted to alter it? Why do we think we're inherently abolishing it?
Mr. Blooster.
Well, Mr. Chairman, Mr. Smith, the reason we're not frankly, as far as abolishing, we're not talking about an abolishment of the Constitution, but it's there in case they wanted to do it. That's why they put it in there. The other thing that comes up is, how are you going to determine who the delegates are? Congress tells that the states are going to determine how many delegates are going, and also I think you have to look at the psychology of a convention. I'm going to get into this in 2017, but you have to look at the psychology of a convention as opposed to Congress or the state legislature. The psychology of the delegates to a convention is much more limited to their constituency is much more limited than your constituency is members of the legislature or those of the Congress. And consequently, it can be manipulated a whole lot. Just ask Ron Paul's delegates to the convention and what happened when the microphone was taken out of the hand of the delegates and he wasn't able to speak. That's the kind of thing that can happen in this kind of a convention, and I submit that if the wrong delegates get to that convention, that could very possibly happen. I think there are just so many things that can happen that we have no idea what's going to happen in a convention of this sort.
Thank you.
Thank you.
Further questions from Mr. Blooster, Representative Wheeler.
Mr. Chairman, thank you. Mr. Blooster, let me see if I can get a real easy, simple answer to this question, and I'm going to try and do it right. So if the proponents of this legislation succeed, the legislation requires a balanced budget. It says nothing about reduction in spending.
Right.
So isn't it totally feasible, totally possible, that with all the successes they purport to have, that everything goes their way, because it's only a balanced budget amendment, that all delegates and Congresses and legislatures have to do is increase taxes to satisfy the balanced budget requirement?
To me, that's a logical conclusion.
Thank you.
Mr. Wheeler.
Thank you. Any further questions for Mr. Blooster? Thank you for your testimony.
Thank you, Judge.
All right, next we will hear from, who did I call up? Mr. James Pinkerman. Okay. Okay, then next we have signed in wishing to speak Leonard Clark against the bill.
Thank you, Chair and Committee. I'm sorry, I'm a regular citizen here, so I'm not used to testifying. And I also want to thank all the people that are sitting here. Normally, I would be in here opposing what, the conservatives are doing, and I'm the lefty on the left and the right. But you know what? I've heard, Mr. Chairman and Committee, on this particular House concurrent resolution are some good arguments from the left and the right. I am a fanatic for something. I'm a fanatic for moderation. I'm a fanatic for our democratic republic. I don't like this tinkering around. Our world is changing so fast now. And I think that scares a lot of people. And I feel that this concurrent resolution, in a way, might be even subconscious our response to that. Because I know everybody in here loves our country, our republic, our constitutional democratic republic. I'm not even speaking as one of those crazy tree-hugging lefties or patriot-loving conservative righties right now. I'm just saying we have so much that is changing so quickly. Facebook, internet. It's a very scary time for our country. So I feel that the Constitution is the one thing right now, in this time of instability that's going around the world, and now you hear about people shooting at our power plant in California. We don't know who they were attacking it. Right now, we need to know we have something to depend on. And that's why I oppose this, but I do really, really believe in your conscientious feelings, that you really believe in what you're doing. But, I'm finding myself, it's kind of stunning to myself right now, agreeing with people I would normally consider way over on the far right, and, I'm on this left over here. This is the one thing that's not changing so much right now. We still have what our forefathers have given us with that. Why give a chance to even make more change? Because I feel that the nationalism, which I don't think is a bad thing, is dying quickly. And this isn't going to save it by maybe opening up the Pandora's box. So thank you for letting me have the honor as a citizen, because I'm here representing myself. I'm native of Phoenix, and I feel it's an honor to be able to come here, because I know so many friends of mine who couldn't be here, who service members, and I just really, really am glad we're not fighting each other right now. I've been to other countries where that happens. Oh, I just lost my candy. So I will leave you with the free candy the House of Representatives has given out. Thank you, and I don't think you have any questions, but if you do, you can Chair and committee.
Thank you, Mr. Clark. And I just, I mentioned this to you before, but I appreciate your involvement in this process. I know that you pay attention to a lot of the bills that are moving through the legislature and come down and weigh in on many of them. When you can't come down, you register your position online, and I appreciate your involvement. It really is important and valuable. Are there any questions for Mr. Clark? Thank you for your testimony. All right, next we'll hear from, let's see, Gerard Schneider. I'm sorry, Schneier. Hopefully I pronounced it right. You can correct me when you come to the podium if you'll please state your name for the record. And following Gerard, we will hear from, and that is the last one wishing to speak. As soon as he's finished, I'll have you come up and state your name at the podium for the record. Okay.
Hi, my name is Gerard Schneier. I'm not a native. I came down here in 2007 from New York City, so I hope you ask forgiveness for that. But anyway, I just wanted to thank you. Good afternoon, ladies and gentlemen. Thank you for allowing me to speak. I want to raise my voice in support of this bill to allow the state to convene an Article 5 Constitutional Convention. Most notably over the last 5 years, but pretty much over the past few decades, the federal government has increased its scope of power beyond those prescribed within the constitutional framework. I may not be a constitutional scholar, however, I can read. It's not in there what they're doing. Every couple of years, we elect people to represent us. Yes, yet once they pass the D.C. border, they forget one key point. We are their employers. Instead, they treat us as peasants and serfs, passing hundreds of laws, creating faceless bureaucracies, which generate tens of thousands of pages of regulations, taxes upon taxes, yet treat us with disdain. We have to pass the bill to see what's in it. When asked where specifically does the Constitution grant Congress the authority to enact an individual health insurance mandate, we're given the response, "Are you serious? Are you serious?" Both of those said by Nancy Pelosi. John Conyers was asked about it, and he said, when asked about reading the bill, his response is, "Why'd read the bill?" I can probably give example after example. If I order a steak, I do not expect it to come out overcooked. If it does, I tell them how it's not ordered right, and I usually get an overworked manager to come out and apologize, and he tells it it's on him. I do not expect a burly, sweaty cook to come out and tell me, "You will take it, you will eat it, you will like it," and then proceed to charge me for 12 more steaks. After all, there is an unequal distribution of steak in America. 2 steaks go for the EPA for their green compliance, 2 steaks go for the Treasury to pay for foreign debt, 3 steaks go for the IRS, and 4 steaks cover the Obamacare mandate. Maybe a steak or 2 goes to the intended target. Somewhere my math has to be off. This is why we need to return power back towards the states and ultimately to the people. It's on loan from us. We can call it back. When Congress has an approval rating of 8%, the President's approval around 44%, and even the Supreme Court's approval is at 43%, it's time to remind them who we are. We are the employers. I know some constitutional scholars consider the Bill of Rights a charter of negative liberties, but what do you call a government that ignores their own populace, creates law without authority, no appeal considered? Now, the Constitution is a charter of restraint against government. It's a carefully thought out document that balances between the liberties and rights of the populace and the needs of the state to protect the freedoms of the populace. Not provide, not transform, not redistribute, not give tax dollars to friends and contributors, but for specific enumerated powers that are clearly defined but ignored. So I ask you to pass this on the hopes of creating more negative liberties, if you could, which will actually return government to its natural and appropriate boundaries. The insanity must end. Even the constitutional scholar admitted that this path is unsustainable, yet he continues. The states have a responsibility demanded of them as prescribed in the 10th Amendment to be a counter to this government. We need to stop the transformation and return power back to the people. Thank you.
Thank you for your testimony. Are there any questions for Mr. Schneider?
And I'm just a citizen. I'm not representing anybody.
Any questions? Okay, thank you for your testimony. Next, if the gentleman will please come to the podium and state your name for the record, and then we'll sign you in if we can spell your name properly.
Hi there. My name is Mark McGahan, M-E-G-A-H-A-N. Looks like Megahan. I'll fill this out in a moment. I'm also just a citizen, not a public speaker. I actually drove an hour and a half from Morristown, which is in District 13, to be at this hearing. I also do so at great expense physically because I suffer from what's called multiple chemical sensitivity, and the air in this room will give me symptoms for 2 to 3 weeks following this. But I feel that it is important enough to say what I have to say today to go through that. And first of all, I would like to thank all of you for your open mind. There's been some great comments on both sides. I understand the concerns as far as runaway convention, but I believe that a lot of that has already been addressed on the materials provided by the Convention of States. And basically, before last October, I was just an average guy. A man named Earl Conlon gave an interview to U.S. News and World Report that kind of caught this country by storm. Whether it was true or not really doesn't make a whole lot of difference at this point, but what he said was that a whole bunch of trucks was on the way down to Washington, D.C. to circle the Beltway 3 lanes deep and arrest every member of Congress and the president. No, of course I knew that that was never going to happen. But along with, I would estimate, 2 to 3 million other people at the time, we all caught the wave. We got behind the trucker movement. We boycotted stores. We waved T2 SDA banners. And we knew that they were never going to succeed in what they claimed to set out to do, but we all kind of hoped that they could. And that message, when people looked around and said, well, what can we do? I settled on Convention of States, and I looked at it. I have a legal background. I kicked it around. I put it under the microscope. And the way I see it, it is the only viable option that this country has at this point to rein in out-of-control government, out-of-control spending. The framework provided by the Convention of States project is what is required in order to provide the uniformity. Every state involved in this has to provide exactly the same language. Everybody has to be on the same page, or it doesn't go through. And I hope that that is something that will address some of the concerns of the people that feel that there's going to be a runaway convention. George Mason, when he was asked to sign the Constitution, said, what are you guys, nuts? The way that this thing is set up, 200 years from now, everybody's going to be drunk from power, from adding on all their own special interests, and they're not going to want to give it up. I'm not signing until I get some kind of an assurance that there's something to be done if that happens. He added the Bill of Rights. Part of that was Article 5. We are not trying to change the Constitution. If we could get our elected officials to do the job that they are supposed to be doing and uphold the oath of office that they took, we wouldn't be in this position. But since we are, like I say, the only viable option that I see for a peaceful solution to our problems is an Article 5 Convention of States. And with that, I'll yield the floor and fill out my paperwork. Thank you.
Mr. Megan, I appreciate your testimony. Are there any questions for Mr. Megan?
Yes.
Representative Seal.
Mr. Chair, Mr. Megan, right?
McGann, anything
McGann.
close.
Mr. McGann, you've looked at it from a lay standpoint. Do you think that the same conformity could be achieved through an interstate compact of the states or a compact of, interstate compact? In other words, that language was the same through an interstate compact to achieve Article 5 called. Are your concerns there
I am not
equally
familiar enough with the compact to be able to address your question, but I will research it so I can look for myself. I always have an open mind on these things. But as a layman and also somebody with a somewhat legal background, I do recognize that you don't need to reinvent the wheel. And Mr. Ferris, Mr. Meckler, the others involved in the Constitution of States project have done considerable groundwork. There is a lot of well thought out legal constitutional research that has already been done. I don't have the skills or the knowledge to be able to say the ins and outs of the minutia, but it's the best program out there, in my opinion.
Mr. Chair, Mr.
McHenn.
Mark.
Mark. Thank you.
Okay, any further questions for Mr. McHenn? Did I get it right? Hopefully. All right, thank you for your testimony. All right, and that concludes our list of folks who have signed in wishing to speak. It looks like we have one more individual who would like to speak. If you could state your name for the record, and the secretary will hand you a slip of paper where you can spell your name so we can make sure we get the spelling correct in the record.
My name is John Harmon McElroy, McElroy, and I'm a retired University of Arizona professor, and that's neither here nor there, I suppose, but it's a fact. And I have written several books on American constitutional or American cultural history, of which the Constitution, along with capitalism and Christianity, I think are the three principal ingredients of our culture. And I wasn't planning on speaking, but I just cannot stay quiet in hearing people talk about the convention in Philadelphia that started in late May and lasted until the 17th of September being a runaway convention. It was not. This is an entirely mistaken view. I happen to have here in a paper that I've given out to people before the hearing that I brought up here to share with anybody that was interested, including some of the speakers that have already spoken. On February 21st, 1787, the Confederation Congress passed a resolution calling for that convention. They didn't specify Philadelphia as the place, but they gave May, the month of May, as the date. There were three principal statements in that, and I want to share that with the committee for your consideration. I am extremely in favor, and have been for years, and have been speaking on this subject of an Article 5 state-initiated amendments convention, because our Constitution is not totally broken, but it is broken because all three branches of the federal government have been illicitly changing it in the way that they have been conducting business. And it's not Democrats, and it's not Republicans, it's not this administration that's in office now or earlier ones. Okay, what did that resolution calling for the convention that wrote our Constitution for the United States? It said three things, principally. Let me quote them. They said that the convention was, quote, for the sole and express purpose of revising the Articles of Confederation, which is what our friends over here are all excited about, that they went beyond that. But the same resolution made these two statements, quote, to establish in these states, they were to revise the Articles of Confederation, to establish in these states a firm national government that would, quote, render the federal Constitution adequate to the exigencies of government and the preservation of the Union. Now, in the judgment of a majority of the 12 states that assembled there in Philadelphia, to carry out that broad directive of preserving the Union required replacing the Articles of Confederation. That was a judgment they made. They produced the Constitution that we've lived under for 225 years. It's a little late in the day to say that we've been living for 225 years under the result of a runaway convention. But it wasn't a runaway convention. They sent this Constitution that they were putting forth, that they had spent 4 months writing and that they had signed, they sent it back to the Confederation Congress with a letter requesting that it be submitted to convention's, quote, chosen in each state by the people thereof under the recommendation of its legislature for their assent and ratification. So, ratification of the proposed new Constitution could have been aborted by either the Confederation Congress refusing to send it to the state legislatures, or the state legislatures, on receiving it, refusing to call for the election of these ratification conventions. None of that happened. The Confederation Congress vetted the Constitution that they received from Philadelphia, and they approved it for consideration by the states. The 13 states received it, they vetted it, and they approved it for consideration by these 13 ratification conventions. So what we have then, gentlemen and lady, what we have is 27 separate bodies of elected representatives of the people of the 13 states then in existence, the Confederation Congress, the 13 state legislatures, and the 13 specially elected state ratification conventions, all playing a role in the final approval of the work done at Philadelphia. Given this fact, how could that Constitution possibly be honestly called the result of a runaway convention, when 27 bodies, not counting the convention itself, which was, established by the states. So we have a situation in our country today in which the three branches of the government that was set up in 1788 with the ratification of New Hampshire in June of 1788 of what was proposed in Philadelphia, we have a situation today where all three branches of the government, the executive, the legislative, and the judiciary, have changed the basic requirements of the Constitution through their own action instead of changing it legitimately through the approval of 3/4 of the states. That's why we need an Article 5 Amendments Convention. It is not a new constitutional convention. The language of Article 5 is very clear. It will be an amendments convention. Thank you.
Thank you, Mr. McElroy. Are there any questions for Ms. Just want to remind members it's not appropriate to applaud during the committee hearing or any other outbursts from the audience, but only to speak when you're recognized at the podium. Are there any questions for Mr. McElroy? Representative Smith.
Thank you, Mr. Chairman. Mr. McElroy, just a comment. You say you stand for our country and our Constitution and our Christianity?
So do all these folks over here and all these folks over there and all of you. Yes, I do, sir.
Mr. McElroy, I appreciate your enthusiasm, but if you could wait till he finishes his question.
Oh, I'm sorry. Yes.
No, Mr. McElroy, again, it's just a comment, but I just want to thank you because it's so weird hearing that from a college professor.
A former college.
Thank you for being here.
Thank you for the compliment.
Representative Seal.
Mr. Chair, Mr. McElroy, you talked about how the initial convention came together in Philadelphia and did what they did. If I understand Article 5 correctly, it grants Congress the authority upon us coming together and creating an amendment. It gives Congress the authority to decide how we in the states are going to ratify it, be it through the legislature and or through a convention of ratifying convention.
Yeah.
And I think you would juxtapose it was different when we had the Articles of Confederation into the Philadelphia Convention.
I'm not sure, sir.
Okay,
I follow
so
your...
what you testified to, Mr. Chair, Mr. McElroy, you talked about when we came, under the Articles of Confederation, we came to the Philadelphia Convention.
Right.
And at that time, the states had said, or the colony states had said at that point that they wanted to, after they did what they deliberated on, it would come back to the legislatures and or the state. In other words, the states would decide how it was ratified, be it the state legislature or a ratification.
Oh, I see your
convention.
point. I see.
Whereas under Article 5, it seems to give to Congress the authority to determine
Well, remember,
what
sir,
method is ratification. And moreover to that point, Mr. Chair, Mr. McElroy, given when we repealed the prohibition, that, from what I understand, was the only time in which we did it.
That's
through
right.
And Congress had referred it to that. And
that's right.
So given those dynamics, do you think, given this language, we might, in turn, that might happen again? Congress might?
No, I don't think that. The reason that your comment, although certainly intelligent, is not really germane was because when they wrote that cover letter, which asked for the Confederation Congress to send it to the states and then for the state legislatures to authorize the election by the people of each state of a ratification Congress, the Constitution of the United States, including Article 5, was not in effect. It had not been ratified yet. So this was entirely outside the procedures that you're citing.
Mr. Chair, Mr. McElroy, to that point, do you think that the procedures in Article 5 are less oriented to states' rights than we were before?
Mr. McElroy.
No, I don't.
Thank you.
I think the whole point of including in the Constitution, it was, if you read James Madison's notes, which I urge everyone in the room to do, it's the next best thing to having been there when they wrote the Constitution. It's much better than the Federalist Papers, in my opinion, as to a full understanding of what was in their minds. If you consider what Madison said, they were, in his notes on the actual convention, they were in some doubt as to whether they should put in that clause about the states having any say at any time in how to propose amendments. They included it only because they were afraid, George Mason particularly, that there might come a time when the federal government itself was so corrupt that they would never propose any amendments to correct their own corruption, which of course is true. That's why the states have to act.
Thank you, Mr. McElroy. Any further questions? Thank you for your testimony. Okay, we have completed the public testimony of those who have signed in wishing to speak. Mr. Vice Chair, if you could please read the names of those who have signed in not wishing to speak but would like to voice their position on the bill.
Mr. Chairman, those that have signed in not wishing to speak are Representative Bob Thorpe for the bill, and he made a note to say, please read into the record, I support this bill in addition to other Article 5 bills coming before this committee. I believe James Pinkerman no, he did not speak, but he's against the bill. If necessary, Linda Brickman for the bill. If necessary, for the bill is Paul Presto. For the bill, Joyce Hill. And for the bill, Theodore Farmer. For the bill, Delmus Edwin Dolly. For the bill, Nicholas Drenius. For the bill, Farrell Quinlan. For the bill, Representative Brenda Barton. For the bill, Representative David Livingston. For the bill, Karen Sunt. And I believe that is all of them.
It is. All right. Members, is there any discussion? All right, seeing none, Mr. Vice Chair, if you could please move the bill.
Mr. Chairman, I move that HCR 2027 receive a due pass recommendation.
Any further discussion? Seeing none, will the Secretary please call the roll?
No.
Mr. Dowd.
Aye.
Mr. Larkin.
No.
Mrs. Leska.
Aye.
Mr. Steele.
Mr. Chair, may I explain my vote?
Please proceed.
I have many trepidations. As I said before, I was much more encouraged by the article using a compact of the states to call for a convention because it put right and codified right there at the same time the safeguards. I am happy that we have passed already out of this committee, and from what I understand, Mr. Dial's work that talks about some safeguard measures at the drafting convention, and to hear that Mr. Thorpe's work is going to be amalgamated or into that, I'm comforted to know that there's going to be some statutory parameters there. And we've got the fundamental argument in front of us if we're going to call for, I mean, whether or not to call in the first place, but if we're going to call, whether it's this limited, arguably strict call that has little or no operands in it other than to call for it, or whether we do something kind of new, which was the Mesnard bill, I would say. I do have several quandaries about it. Once again, I am inclined to vote in favor of this bill so that we keep the discussion going. However, I do want to reserve the option that I may end up voting no on the floor of this. So with that, Mr. Speaker, hopefully, Mr. Speaker, no, I'm kidding. I'm kidding. Justin Olson's a great member, so he'd be a great speaker if you want to do that. Not that that's a ringing endorsement. With that, Mr. Chairman, I vote aye.
Mr. Wheeler.
No.
Mr. Smith.
Mr. Chairman, I'd like to briefly explain my vote.
Please proceed.
Thank you, Mr. Chairman. And again, I just want to thank those that have come down here. I did want to touch on this one issue, though, right quick, about nullification. And we keep hearing, well, we should be doing that. And I just want to say, for the last, at least 3 years, both when I was in the Senate and when I'm here, I remember 3 years ago in the Senate, we had at least 2 or 3 nullification bills. That said, we don't have to listen to the federal government. We don't have to listen to federal law if they place a federal employee or a member of Congress doesn't have to do it. And we tried 3 or 4 or 5 nullification bills, and I supported all of them. Unfortunately, I believe they all failed, much like I supported all the Article 5 pieces of legislation for those 3 years. And they've all failed. And I just want to reach out to those people who are talking about nullification. Yeah, it's a great tool. Sure. Where's it gotten us? Article 5, great tool. Still haven't gotten anywhere with it. So I'm just of the belief that whether it's nullification, whether it's whatever it is, personally, I want to try every tool that's available to us. And I've supported every such tool that has come down through these chambers to try to rein in the federal government and our spending or improper laws that they foist upon us. So I would just lend this to those voices. Just because we want to try nullification again doesn't mean it's going to pass. So what happens when it doesn't pass? Do we just sit here again? So I'm okay with trying more nullification, and I'm okay with trying more Article 5s. I think we all want to get to the same road, but I think we all have to take whatever road will get us there. And we can try them all, but let's try to go down whatever road, right, again, opens up and allows us to go through. So with that, I again will vote aye on this bill.
By way of explaining my vote, I just want to thank everybody who's been involved in this discussion, and I want to thank you for your impassioned feelings about our Constitution and about the government that we inherited from our founding fathers, and want to just reiterate the fact that I share that passion, I share that concern for our constitutional government, and I hope that we can, by whatever tool ends up being the effective tool, rein in the federal government and get back to that prescribed limited federal government that our founding fathers established. I do just want to reiterate that I do think that the Article 5 of the Constitution was placed in the Constitution by our founding fathers for a specific reason. It was debated, it was discussed, and it was analyzed whether the states should have this ability to propose changes to the Constitution, corrections to the Constitution, to try and maintain that balance of power. It gets back to the principle of ambition countering ambition that Madison and the founding fathers discussed, that they understood that the natural tendency of individuals when they get into a position of power is to try and get more of that power. And so they constructed the government in a way that ambition of individuals will limit the power of individuals in other positions of power. And that is the very reason for which the founding fathers put into the Constitution the ability of the states to amend, in addition to the ability of Congress to amend. Congress is a sitting constitutional amendments convention. They can propose amendments at any time. And does that raise fears of a runaway congressional amendments convention? Yeah, it does. And that's the problem. And that's why we need to have ambition countering that ambition in Congress. Congress has been using their position of power to aggregate more and more power unto themselves. The states can get involved using this provision of the Constitution that was placed there for a purpose by our founding fathers, who I believe were inspired by Providence in the writing of the Constitution. And they put this in there for a reason, so that ambition can counter ambition and the states can restrain the growth of the power of the federal government and can restore that balance of power that our founding fathers anticipated. And with that, I vote aye. Members, by votes of 5 aye, 3 nay, you have returned House Concurrent Resolution 2027 with a due pass recommendation.